Hi, this is Rick Durfee with Durfee Law Group, and we are going to answer some basic questions that are frequently asked in the context of estate planning. The first question today is, what is a revocable living trust? And we're going to go on some variations of that, starting with just what is a trust in general. In general, a trust is a contract that controls property or assets over time. Historically, a trust used to just be a contract and not an entity. But in the United States, for various reasons, a trust is an entity, if for no other reason, because the IRS says so. But also, it can have its own tax identification number, it can pay taxes, it can be liable for debts and obligations. So a trust is an entity. As a contract, a trust has three parties. The first is called the grantor, sometimes called the settlor or the trustor or the trust maker. There's lots of words that mean essentially the same thing, but it's whoever creates the trust. With a revocable living trust, that's typically you if you're creating that for yourself. The second party is the trustee. The trustee is the executive that runs the trust, that carries out the instructions and directives of the grantors who create the trust. One of the things we do in a trust is we designate, well, who's going to be the trustee over time. In the beginning, with a revocable living trust, the trustee will typically be the grantors who are creating the trust. But over time, others might become trustee or will become trustee. If the grantor becomes incapacitated, another family member or co-trustee may be added. And when the grantors are deceased, then obviously they can no longer be the trustee, so somebody else is going to be the trustee. And that's one of the significant questions. Who's going to be the trustee when it's not me? Is something that we address in the estate planning process. The third party are the beneficiaries. These are the people that enjoy the assets that are owned by or transferred to the trust. Typically, again, with the revocable living trust, the grantors, the people creating the trust, are also going to be the trustees, and they're also going to be the beneficiaries. So because the grantors are in all three seats, grantor, trustee, beneficiary, they're basically entering into a contract with themselves. And they're taking their assets and saying, I'm giving my assets to myself in trust for my own benefit. But then there are rules established. The grantors create rules. Who's going to be the trustee after me? Who's going to be the beneficiaries after me? When and on what conditions and in what manner do the other beneficiaries receive the assets of the revocable living trust? Some other significant features of the revocable living trust is that the grantor has the power to revoke it, which means they can amend it, they can change it at any time. So the grantors are the rule makers, and the people who make the rules can change the rules. And because the grantors sit in all three chairs, grantor, trustee, beneficiary, and typically convey their own assets to the trust, historically, this kind of revocable living trust does not protect assets from the creditors and liabilities of the grantors. Those assets are still available to your creditors. It's not a clever device to do asset protection. Now, some states have what's called a self-settled asset protection trust. That's a topic for another discussion. A revocable trust is not such a device, typically. Now, that doesn't mean a revocable trust cannot protect assets, but that protection does not arise until the trust becomes irrevocable. When does a revocable trust become irrevocable? Typically, when the people who have the power to revoke it are dead. So one of the dumb things we see people do is using the word revocable in the name of their trust. My revocable trust. Well, as soon as you're not here anymore, that trust is now irrevocable. So it's usually a bad idea and an indication of poor thinking. We're not thinking about how this trust is going to function over time when we use the word revocable in its name. So even though we might describe it as a revocable living trust, it should not have the word revocable in its name. And whether or not a trust is revocable is not a function of its name, because people who name their trust Revocable Living Trust that trust will become irrevocable when they die. So now it's an irrevocable trust with the word revocable in its name. So we have to look at the underlying content of the trust to determine whether or not it's revocable. The revocable living trust, because the grantors and the trustees and the beneficiaries are all the same, is typically a disregarded entity for income tax purposes, which means it's the same as if it's just not even there. The grantors use their social security numbers on any bank accounts or other instruments created with respect to the trust. They also report their taxes the same as they always have. Having a revocable living trust does not change your income tax reporting. Some very significant functions of the revocable living trust. First and foremost, the biggest and first reason why people form the trust is to avoid judicial proceedings or litigation or probate when they pass away. The revocable trust can also do some significant estate tax planning for individuals and their estates when somebody passes away. And of course, the revocable living trust can manage when, how, and upon what conditions assets are used for the benefit of or distributed to other people after the grantors are no longer living. So the revocable living trust is the engine that drives most estate planning in the U.S. Most people, if you have an estate, you need a revocable living trust. There are alternatives to the trust that can avoid probate that are appropriate in certain circumstances, and that's a subject matter for another discussion. But here's the key takeaway from this. A revocable living trust is a contract that controls your assets over time, because you're going to be in all three of those positions, the grantor, the trustee, and the beneficiary. You do not surrender control. If it's properly crafted, you do not surrender privacy. You do not trigger some unexpected or unwanted income tax consequence. The revocable living trust is your alter ego. It's you. But it is a plan that is put in place in advance so that when, not if, when you either become incapacitated or pass away, you have mapped out what's going to happen, which is why we call the trust a contract that controls your property over time. So the revocable living trust, an essential component of any estate plan. If you have questions about your trust, if you have an old trust that needs to be reviewed, if you're wondering, do I really need one of those revocable living trusts, we encourage you to check out some of the other educational materials on our website, and if appropriate, call and schedule an appointment for one of the attorneys of our firm to visit with you.